Good afternoon. My name is Alexa Barkley, and I'm a survivor of sexual assault. I'm joined today by my colleague Tanya Cooch, with whom I founded Survivor Safety Matters. Also with me are Sylvia Samsa, Executive Director of SAVIS of Halton, Pam Damoff, Member of Parliament in Halton, Julia Fiddes, Executive Member for the Ontario Coalition of Rape Crisis Centres, Dr. Benjamin Roebuck, Federal Ombudsperson for Victims of Crime, and Huri Hamboyan, Senior Advisor to the Federal Ombudsperson for Victims of Crime. We stand together today to bring your attention to a matter of utmost importance, which is putting safety at risk for those brave survivors of sexual assault who choose to engage the Canadian justice system. Section 278.1 of the Criminal Code of Canada allows for the disclosure of private records of the victim during criminal proceedings. Private records at risk of disclosure include therapeutic and counseling records, personal journals and diaries, as well as other documents for which there is a reasonable expectation of privacy. Section 278.1 is one of the few instances in Canada where a person's right to privacy, as afforded to all Canadians under the Privacy Act, is overridden by the fact that they have reported sexual assault to the police. While the intention of including personal records is said to be to protect the accused's right to form a full defense, the reality involves significant traumatization of the victim. Reporting sexual assault exposes the victim to complete scrutiny with no equivalent for the accused. While on the surface, Section 278.1 appears to protect the survivor by imposing a hearing to determine the relevance of private information, feedback from the survivor community tells us that record requests are consistently being approved by judges. Survivors who have already been deeply violated by sexual assault are being further victimized by the Canadian justice system's willingness to include sensitive personal records in the court process. I can personally attest to the profoundly negative impact that the inclusion of personal records has on a victim. As a child, I was the victim in a sexual assault case in which my personal records were used to discredit and attack me, causing me to become emotionally overwhelmed and ending my participation in the court process. As an adult, I again faced the threat of my personal records being included in court and used against me, which was especially traumatic given my first experience within the Canadian justice system. There's an automatic publication ban that exists around Section 278.1 decisions, making disclosure a criminal offense. Based on this fact, I cannot disclose the details of the personal record inclusion in my adult case. Tanya Cooch is a brave survivor who has endured both the military and civilian justice systems, losing her chance at justice due to expansive personal record requests related to Section 278.1. I'll invite Tanya to provide us with her own experience.
Thank you, Alexa. So my case was one of the first military sexual assault cases transferred to the civilian justice system when the Canadian Forces National Investigative Service, the CFNIS, laid 3 counts of sexual assault against my former commanding officer in the Ontario Court of Justice in July 2021. More than 4 years after my complaint was initially reported. In April 2017, when I was a brand new officer cadet, I was attempting to escape from the situation and was directed to contact the Sexual Misconduct Support and Resource Center, the SMSRC. They were able to provide me with assistance and support. As a result of the trauma from the sexual assaults, I needed to get counseling. I was deteriorating and no longer able to function. It was such a violation of my whole being. Everything about me was shattered. All of this led to me having to take a medical leave from work. I mentioned my counselor during my second CFNIS interview in November 2017, and I had no idea that this disclosure meant that my counseling records would be open to subpoena by the defense to be used against me in the court process. This innocent disclosure was all it took to permit the defense to subpoena 7 years of my counseling records and 7 years of records from the Sexual Misconduct Support and Resource Center, which a Superior Court judge signed off on. These subpoenas were date-ranged to the present, which meant that I could no longer safely speak to my counselor or receive support from the SMSRC. Nothing was confidential anymore, and so I felt forced to cut off all contact with them. I was provided with a Section 278 lawyer who told me that based on her experience, she thought the judge would likely grant the defense's request for access to my personal records. To give you context, the defense had used the threat of going after my counseling records for over a year and a half before their Section 278.1 application was submitted to the court. I found this to be a perpetual witness intimidation and bullying tactic to try to cause me to drop out of the court process, which was eventually successful. My main concern was that my counseling records would reveal that I began journaling in July 2017, and this would mean that the defense could also subpoena my personal journals, which I needed to help me recover during the 2,321 days from the date my case was reported until the case was stayed on September 1st, 2023. Section 278.1 of the Criminal Code forced me to choose between protecting myself from further violation by the court or continuing with the court process that we all rely on for justice. My case could have gone to trial based on the evidence gathered by the police to support the charges that were laid. The inclusion of my sensitive personal records was irrelevant to the crime being tried. The provisions of Section 278.1 of the Criminal Code have nothing to do with justice and everything to do with the justice system being used against complainants who report sexual assault. For this reason, I contacted the Office of the Federal Ombudsperson for Victims of Crime, who has now launched a systemic investigation into how victims of sexual assault are treated by the Canadian justice system, including a look at Section 278.1. Dr. Roebuck, I invite you to speak.
Thank you, Tanya. Thank you, Alexa. The Section 278.1 regime was developed to protect the rights of survivors of sexual assault, pour protéger le droit à la vie privée des survivantes d'agressions sexuelles. In 2022, the Supreme Court affirmed that it was constitutional and that it balanced the rights of the accused to a fair trial. However, they also affirmed that judges must consider society's interest in encouraging the reporting of sexual assault offenses, à encourager le signalement des infractions d'agression sexuelle, and society's interest in survivor access to treatment. The Canadian Victims' Bill of Rights is quasi-constitutional legislation that further guarantees every victim the right to have their security considered and to have reasonable and necessary measures taken to protect them from intimidation and retaliation. Mesures raisonnables et nécessaires soient prises pour le protéger contre l'intimidation et les représailles. Today, Alexa and Tanya are bravely telling Canadians that these criteria are not met by the current 278.1 regime. Our office has launched a national systemic investigation into how survivors of sexual assault are treated in the criminal justice system. Notre bureau a lancé une enquête systématique nationale sur la façon dont les survivants d'agressions sexuelles sont traités dans le système de justice pénale. As Federal Ombudsperson for Victims of Crime, I believe these concerns are serious and require attention. Ces préoccupations sont sérieuses et qu'elles méritent une attention particulière. Survivor safety matters. La sécurité des survivants et survivantes prime. Merci. Alexa.
Thank you so much, Dr. Roebuck. There are two additional key points that should be considered in the discussion related to 278.1. Firstly, we are aware of multiple instances where expansive record requests were made too present, functionally cutting off a victim's access to safe mental health and support during an exceedingly stressful criminal justice process. Court proceedings can be stopped at any time for the defense to make additional records requests, which means that victims are not safe to reach out to available mental health supports until after the trial has concluded. Secondly, the disclosure of sensitive and personal information to the defense is extremely problematic in that it offers the accused sensitive personal information about their victim, which could be used in retaliation long after the court process is over. Survivor safety is a critical issue that affects individuals across our nation. Survivors of various forms of trauma require robust support systems to heal and rebuild their lives. Ensuring their safety and privacy is paramount in this process. Even the threat of having their private records being disclosed to the offender and possibly to the public in court creates a significant barrier to seeking help. Our petition E-4749 will be tabled in the House of Commons. We are calling on the Government of Canada to unconditionally protect the privacy and safety of victims of sexual assault and eliminate the provision in Section 278.1 that allows for the defense to subpoena personal sources of support. Even the threat of having a victim's personal counseling, therapeutic records, or private journals being brought into court and given to the offender is undeniably harmful to the victim and undermines the proper administration of justice and access for both the offender and the complainant to a fair trial. We're happy to take any questions.
We will take questions on Zoom. If you have any questions, please use the raise hand function. Thank you. This concludes the press conference.
Thank you so much.